Hello everyone, and welcome to this video tutorial on intention to create legal relations in contract law. Intention to create legal relations is defined as an intention to enter a legally binding agreement or contract. Intention to create legal relations is one of the necessary elements in formation of a contract. If there's no agreement by both of the parties, it may make the contract void. To save time, we abbreviate intention to create legal relations to ITCLR because it is a bit of a mouthful. The requirement of ITCLR in contract law is aimed at sifting out cases which are not really appropriate for court action. Not every agreement leads to a binding contract which can be enforced through the courts. And it might be a good idea at this point just to pause this video and to jot down all of the different agreements, promises that you made this week. Might have been with friends, family, teachers. Think of all of those different agreements, and for each, think about, should they be enforceable in court? So just take a minute or two to do that. Okay, if you're back with me now after listing some of those examples, to give you an example that I came up with, I had an agreement to meet a friend at a pub. Now, I had a moral duty to honour that agreement, but not a legal duty to do so. And this is because, in general, the courts, the parties to such agreements, do not intend to be legally bound. Yeah, so even though I've made that agreement with my friend, she might be disappointed if I don't turn up. It's not a very good thing to do, but she wouldn't expect court action as a response to that. And in general, the law seeks to mirror the parties' wishes. So if there's no indication that me and my friend want to be bound by this promise to go to the pub, then it'd be absurd for the courts to be going about trying to enforce those promises. So in order to determine which agreements are legally binding and have an intention to create legal relations, the law draws a distinction between two different types of agreement. You can see here on this slide that there are two types of agreement that the court recognises and differentiates. There's business agreements and there's social agreements. And as you might expect here, that in general, with a commercial or a business agreement, the courts presume that there is an intention to create legal relations. Whereas in social and domestic agreements, the presumption is against intention to create legal relations. So if you created a list of the sorts of agreements you made last week, they were probably mostly, if not all, social and domestic agreements. And in general, the court would not be trying to enforce those. That's what this general rule is. So we're going to have a look at some cases on these two different types of agreement, and we're going to start with commercial and business agreements. So the first case that gives us the general rule on commercial agreements is Edwards and Skyways. And this was a commercial agreement about a redundancy payment that was due to be made to an employee. And the company were going back on their promise to make this payment. And the claimant sued and wanted to enforce this agreement. And what the court said here was that there was an intention to create legal relations between the company and the employee because employments made in a business context raise a strong presumption that the agreement is to be legally binding. So this is showing us really that generally agreements between bosses and employees, you would expect there's a strong presumption for ITCLR here. Another case on the same point here is Esso Petroleum. And in this case, Esso was giving away a free World Cup coin with every 4 gallons of petrol that were being purchased at its pumps, obviously to encourage people to be buying more petrol from them. And millions of these coins were distributed. Customs and Excise were trying to claim that the coins were essentially being sold and therefore they could get tax from them. And since Esso was trying to gain extra business, i.e. encourage people to buy more and more gallons from them, there was an intention to be legally bound by the agreement. And this is showing us then that if it's a business or it's a commercial agreement, even something that looks like a bit of fun, if you like, an offer or a giveaway, they're designed to promote a business. And these sorts of offers and giveaways and gimmicks still create a presumption in favour of the intention to create legal relations. And generally, they're going to be enforceable. You might be thinking that this presumption in favour of creating legal relations for businesses and companies seems a little bit unfair, but to make it fairer, the courts are prepared to accept that the presumption in favour of ITCLR can be rebutted if the business shows that it wasn't intending it to be binding and that it communicated this clearly. And that's illustrated in the case of Jones and Vernons pools. Vernons pools was a type of lottery, and they inserted a clause onto their coupons, onto their tickets, stating that this game was to be, quote, binding in honour only. So this phrase means that the company were not expecting this to give rise to any legal relationship. The claimant won and sent in his coupon, and he tried to claim his winnings, but the court said he was unable to claim because of this clause, binding in honour only. That prevented the claim because it negated or it took away the intention to create legal relations. So this is showing us quite clearly that commercial agreements can rebut or they can get rid of the presumption that they are legally binding simply by stating that it's not binding. And that's all they're saying there. We're not going to be bound by it. It's not going to be a valid contract. So you've got to read your small print and look out for phrases like that. Similarly, we've got the case of Confetti Records, which is on the same point, still looking at the commercial context and how they can rebut the presumption. So here, our defendant wanted to use a song which was owned by the claimant on a compilation album, like a mix CD. And after negotiations, he sent a fax to the claimant detailing the terms, and it was marked, quote, subject to contract. The claimant faxed back a signed copy and sent a CD of the track with the invoice. The claimant then said that they wanted to renegotiate terms. The track wasn't to be used yet, but the defendant's compilation album had been recorded and manufactured at that point. And the claimant was then suing to try and stop this track being used. And the issue was, did they have a binding contract to begin with? Was their intention to create legal relations? And the court looked at the facts and saw this phrase, subject to contract, and they said that use of that phrase on a document acts as an exception to the general rule that commercial agreements are intended to be legally binding. So this phrase worked the same way as in the Vernons pools case. In that case, it said binding in honour only. Here it's saying subject to contract, but they're both achieving the same thing. So with these little phrases, commercial agreements can easily avoid the intention to create legal relations. Let's turn then and consider the situation with social and domestic agreements as opposed to commercial agreements. We're going to start with the case of Jones and Padavaton here, and this is a leading case on contract law, and the decision demonstrates how domestic agreements, such as in between a mother and a daughter, are presumed not to be legally binding unless there's clear intention. The facts of this case were that a mother and daughter came to an agreement where the mother agreed to pay the daughter if the daughter agreed to study for the bar. The daughter commenced her studies and her mum was paying her an allowance. And they later tweaked the agreement and the mother agreed to provide a house in which the daughter could live in while she studied for the bar. The mum and daughter then fell into dispute and the mother tried to recover the house. And the daughter said, no, we've got a contract. And the issue for the court was their intention to create legal relations? As you would expect, the mother was successful here and she was awarded possession of the house. And the court said that there's a presumption that family arrangements are based on mutual trust, family ties, affection, and that there's no intention to create legally binding contracts capable of enforcement in the courts. They did say that the presumption can be rebutted, but the lack of formality in this case regarding the agreement between the mother and daughter strongly indicated that there was no such intention and the daughter had no claim here. And this case is showing us that in general, agreements between parents and children or family arrangements are not intended to be binding. Looked at case involving a parent and child. Let's have a look at some cases on husbands and wives. Firstly, we've got Balfour and Balfour, which we studied in first year law when we were looking at judicial precedent. So in Balfour and Balfour, there was a husband working overseas and he agreed to send maintenance payments to his wife. And at the time of that agreement, the couple were happily married. The relationship later soured and the husband stopped making the payments and the wife was trying to enforce his agreement to make these payments. And here it was held that the agreement was a purely social and domestic agreement and it was presumed that the parties did not intend to be legally bound. And a key factor here was that they were still happily married when this agreement was made. We always compare this case to the case of merit and merit, which if you remember from studying precedent, merit and merit was distinguished from Balfour and Balfour. Merit and merit, what happened was a husband left his wife and went to live with another woman. And there was £180 left owing on the house, which was jointly owned by the married couple. The husband signed an agreement whereby he agreed to pay his wife £40 a month to enable her to meet the mortgage payments. And if she paid all the charges in connection with the mortgage until it was paid off, he agreed that he would transfer his share of the house to her. When the mortgage was fully paid and the wife had stuck to her terms of the agreement, the husband refused to sign his share over to her. And again, the court had to look at, was their intention to create legal relations? And here the court said that the agreement was binding and they distinguished it from the earlier case of Balfour and Balfour. And they said in merit and merit, the couple was already separated and they'd also written and signed an agreement, which wasn't the case in Balfour and Balfour. So there was further evidence through this signed agreement that they did in fact intend to be bound, so it was enforceable. So we've seen there in merit and merit, it is possible to rebut the presumption that social agreements are not intended to be legally binding between husband and wife. If we look at Wilson and Burnett, this was an agreement between two friends about sharing money at the bingo. And this case said that there must be certainty and clarity to rebut the presumption that social agreements are not intended to be binding. We had that clarity in merit because there was a signed agreement, it was very clear. But here in this particular case, there was a bit of a discussion, but there was no clarity. So the presumption was still in place. Our final case on social and domestic agreements is Simpkins and Pays. And in this case, a lodger entered a competition with two members of the household. They each paid in on the understanding that they'd share any winnings. And the agreement here was enforceable because money had exchanged hands. So this is actually a really useful case because what it tells us is that in a social agreement, if the parties have exchanged money, the courts are likely to believe that there's an intention to create legal relations. So always look out for that in scenarios. If it is two friends agreeing on something, have they exchanged any money? Because if they have, that is likely to rebut the presumption. Just to end here then with a summary, it's very straightforward ITCLR. What we've seen in this video is that commercial agreements have a strong presumption that they're legally binding, whereas social and domestic agreements, there's generally a presumption against ITCLR. But what we've seen for both is that it is possible to rebut those presumptions if there's clear evidence.